As we would all know, a lot of the regional bodies that we have on the continent, if I may be specific, ECOWAS, East African Community, and SADC, were initially formed with the main purpose being to develop economic integration. So the main focus was economic integration. In the recent past, these organizations have begun to play a bigger role than simple economic development. This is not by accident. The experiences with economic development have shown that unless economic development works side by side with the enhancement of governance, economic development won't work. So you find that these organizations have set up supranational courts that seek to enforce the treaties that build these communities, and in addition, strengthen the rule of law and offer greater protection for human rights. The reason is that there is an obvious link between economic development and the confidence that investors and economic partners have with the economic environment presented. A country that has a chaotic politics, that is unable to protect private property, that is unable to offer resolution of economic disputes cheaply and expeditiously, is not going to attract investment. Who wants to put money in a country or in a region which cannot secure that environment? So it is natural that we have seen these supranational courts emerging. But with the development of these organizations that first started off as economic development institutions with a greater political agenda, there was less free flow of information. We all know that our leaders, political leaders, would go to meetings, be it an OAU meeting or African Union as it is known now, SADC meeting, etc., with less citizenry participation. Now, it is necessary that citizens know what is in these protocols, what decisions have been taken, because citizens have rights that they may want to enforce through the mechanisms presented by these regional bodies. So there is first access to the information relating to the workings of these organizations, and obviously there are organs like the courts that are established. This information is important because without information you can't understand or enforce your rights. You can't participate fully unless you are informed. So you need to know what happens within these bodies for you to be able to participate fully as a citizen. Access to information in itself ensures that there is good governance. At least we can challenge bad governance because we would know about the decisions that have been taken. It creates accountability. The majority of us may be aware of the constant issue relating to the role of the EU vis-à-vis Britain. That constant debate that seems to happen every year and is emotional is based on the reality that the introduction of regional bodies in many ways affects the workings of individual countries and subsequently affects the rights and duties of citizens. So it is incumbent that these bodies that are formed, to which our countries are members, allow us as citizens of the regions to be able to access that information that relates to their running, their decision-making, and their governance. For the purposes of our meeting, we are more concerned about access to legal information. Any modern democracy that is pinned upon an efficient administration of justice must be open in the manner in which it makes its decisions, passes its laws, appoints its judges, etc. It allows us to have confidence in the dispute resolution mechanism. Judicial decisions and the statutory protocols need to be available to the litigants, to students, to practitioners, and to the judges. We all know from the workings of the African Commission how many of our citizens and NGOs take matters to the African Commission after they have failed to find effective remedies in their own domestic countries. It is important that any person who decides to take that step is aware of the previous decisions, at least of that African Commission, previous decisions of organizations that operate within the same political and economic environment. Decisions of judges interpreting the protocol or making decisions relating to the rights that are concerned are very important. I speak from a common law tradition where it is incumbent upon practitioners, judges, to receive the most recent decisions of courts, because decisions of courts interpreting the common law and interpreting statutes are the law. A decision of a court on the common law is as effective as a statute. But even for those that are in civil law jurisdictions, there has already been a blurring of the lines, particularly with regards to human rights law. The European Court of Human Rights, for example, is a court for jurisdictions that have a common law background and jurisdictions that don't have a common law background. Yet, when it makes its decisions, it effectively follows its previous precedents, which makes it very important for one, whether you come out of a common law or a civil law jurisdiction, to want to understand the decisions that they pass. In fact, Brazil has in the recent past passed a law that requires lower courts to follow decisions of superior courts, notwithstanding that it is a civil law jurisdiction. The reality is that consistency and predictability of the law reduces the costs that might arise if each different court at different level makes its own decisions and does not follow a proper thread of thought. I've already spoken about the predictability, but predictability, as I have said, depends on publicity. A lot of our African countries, I'll give an example of the Southern African region. You find that there is bigger flow of decisions from one jurisdiction to the other. The decisions you'll find in Swaziland, Lesotho, South Africa, Botswana, Namibia, Zimbabwe, for example, show a particular Roman Dutch jurisprudence because of their common legal tradition. Practitioners even practice in one jurisdiction, move to the next and to the next, to the next. Judges even are appointed in various countries because of that common tradition. It helps a lot that they're able in their work to access decisions from the various jurisdictions. As we move further afield, we have differing legal traditions. If we are going to have effective supranational courts, how can they become effective and present uniform decisions if they are unable to access laws from the various jurisdictions that make up that regional bloc? A project like AfricanLII, working with supranational courts to collect information and put it out there for access by judges and practitioners, etc., enables the users of the information to be able to compare. And the development of jurisprudence based on comparative, on comparison, is stronger than the development of a jurisdiction based upon individual countries at a regional level. One of the complaints already being raised about some of the regional blocs is that there is no consistency in terms of their decision making. A development that will enable them to access the various information that is out there will assist in aligning the decisions of regional blocs in a more consistent manner. Access to law is important to civil society and the rule of law and to the economic life of everyone in the region. But we know that in our African continent, it is difficult to get access. There are many reasons for it, but this project is targeted at trying to obviate the majority of the problems that we have, which are cost-based, and also which are based on the fact that we are not cooperating enough. I will skip the part relating to what it means to be accessible, but it is important for us to note that there is no way that we'll be able to maintain or promote the rule of law unless our laws are accessible and unless they are intelligible, clear, and predictable. And that can only happen if we are able to produce a comprehensive collection of our decisions, comprehensive collections of supranational decisions, comprehensive collections of protocols, comprehensive collections of national statutes. I've already spoken about the benefits relating to attracting investment, so I will not burden you by going comprehensively into that. The Honorable Chief Justice has already spoken about the free access to law movement, which I think you'll hear about from subsequent speakers. It suffices to mention that it is a movement that believes that it is through sharing of legal information that we are able to hold our governments to account, to hold our judgments, our judiciary to account, to ensure that our democracy is strengthened. AfricanLII is part of that family of leis. The Honorable Chief Justice has already spoken about SAILI. There are several that you see at the bottom of the banner here that we have set up across the region in the individual countries. They publish law via the internet, and their decisions of their courts are easily available. You can access them for free. The use is anonymous and free. And if there are any other organizations that would like to take that information for use, it's freely accessible. The whole idea being that by sharing that legal information, we are able to strengthen the quality of justice, we are able to share more, we are able to cooperate more. I've already spoken about the improvement of governance, but courts that make decisions behind closed doors and do not publish the reasons for their decisions are as good as non-existent. Because, as the saying goes, judgments are written for the one who loses. It is important when our courts make decisions that we understand the basis upon which they are made. That is only when we are able to say, does this decision of the African Court of Human Rights accord with the African Charter? We hold them to account. We also want our supranational courts to have a wealth of municipal law from which to draw, for them to be able to say, at the African Court of Human Rights, we will follow what the Supreme Court of Nigeria said. It makes much more sense than what the Supreme Court of Namibia has said. To have that comparison. What we have at present is that in the majority of our own countries, it is easier to get a decision of the United States Supreme Court, easier to get the decision of the Supreme Court of the United Kingdom, easier to get the decision of the Australian High Court, easier to get the decision of the Canadian Supreme Court. And yet, a jurisdiction next to you, which operates in the same environment, which probably has a similar legal tradition, you can't get their decisions. As a result, some of the developments of our laws have been fairly artificial. because we are not grounding the decision-making in some of the shared experiences. We also, by these projects, intend to ensure that there is more and more legal research done at a regional level, comparison of laws, improvement of laws, based on an appreciation of laws that exist beyond our own municipal jurisdictions. We would also, by making legal information easily accessible, reduce the costs of litigation. By this I mean, lawyers love to charge by the hour. And if it's going to take him 10 days to get that piece of legislation from Liberia in order to give you advice on whether you can send money to open a diamond mine in Liberia, he'll charge you for the 10 days. But it might have taken him only 5 minutes to give you the answer after discovering the document. So you have paid for 10 days which were unproductive. That is the impact that poor access to information has. Secondly, we all use Google. If you go to your medical doctor today and he tells you you have this ailment, the majority of us go home and sit and look at Google and look at what the symptoms are, what the drugs are. We all have a fair appreciation of the information that we can get from Google that is simplified for us. That is the nature of the world now. People go and find out information on their own. So what makes law special? That you should go to a legal practitioner first for him to enunciate for you. As you go on the internet now, there are lots and lots of simplified blog writings on specific issues relating to the law. Information is being simplified. It would be better for the citizenry to walk in the lawyer's office and say, I have read 1, 2, 3. It shows that if I do 3, 4, 5, I might be able to invest in Liberia. Can you confirm whether that is true? It's cheaper for you because you have done the basic work for yourself. And the lawyer does not charge you for consultation that was unnecessary because he has to understand your problem. Some of it is very simplified. Applying for a liquor license, for example, which is a huge economic activity in some of our communities. Applying for a business license. Why should you go to a lawyer if your government has put the forms online? This is the forms you need to fill, and these are the accompanying documents you need to submit. We reduced the cost of legal services by ensuring that this information is freely accessible. In fact, a lot of expertise that we seek is simply based on ignorance, not because we can't read for ourselves, but simply because the repositories of that information is restricted. We can't all have access to it. That is why it is critical in terms of legal information for us to have access to as much information as we can so that we can, on our own, formulate ideas about matters that relate to us. We offer a solution that is internet-based because, as the majority of you know, just last week the new chairperson of the AU Commission, which is the executive board of the Commission, a former South African minister, got to Ethiopia to start work 2 weeks ago, and then discovered that 97% of projects that are AU projects are in fact funded by foreign organizations outside Africa. 97% of all AU projects are funded outside Africa. It's not a good reflection on us, but the reality is that we actually don't have much money. So a solution that is internet-based obviates part of our problem in that it offers a cheaper distribution channel for information. We come from adversarial systems, the majority of us. or even a lot of the supranational, sorry, I keep on calling them supernatural, but they're actually supranational bodies operate on the basis of an adversarial system. You go with your complaint to that court. If it's against your government, the government comes with its side of the story. You present your case, they present theirs. And then the body makes a decision. If your government has this advantage of information simply because your government participates in these organizations more than the citizen, the playing field starts at a skewed level from the beginning. Making this information easily accessible means that by the time you go to the African Court of Human Rights, by the time you go to ECOWAS Court, by the time you go to the East Africa Court of Justice, you already have sufficient information about the decisions made, the protocols that exist, previous decisions made, and therefore you can be able to tip the balance in your own favor because you have information. You can also lobby for treaties. Those of you who follow what has been happening with the SADC tribunal that Justice Mukanda is registrar for, would know that in the last 3 to 4 years, there's been an emotive fight across many battlefields, many battlegrounds over the proposed abolition of the SADC tribunal. Now it has been adjusted to change its jurisdiction. There are still issues going on and on and on about it, with civil society saying that we need this body that holds our governments to account because sometimes we don't have effective domestic remedies. But one critical issue that came out was that there was need for a strong lobby to show that these bodies are important. I was just chatting to Justice Mukanda earlier today, and he gave the example of the dispute between Malawi and Tanzania over Lake Malawi. That is a matter that falls straight under the jurisdiction of the SADC tribunal. And there is need for agents